Hello there, Andrew Bethel with the Bethel Law Corporation, and today we're going to be discussing a pretty commonly asked question in our office, and that is whether or not our clients are required to or whether or not they should provide a copy of their will or trust to their children during their lifetime. So generally, no, there's no requirement that you provide a copy of those documents to your children during your lifetime. They are private documents and they should remain private during your lifetime. There is some disclosure requirements after your passing, but we'll get into that a little bit later in the video. In general, we typically recommend our clients keep those documents in a secure location and at most just inform their children that those documents are in existence, but really you want to make sure your executor and or your successor trustee under your trust, that is the person you want to step in and manage your affairs, just make sure that they at least know where to find those documents when the time comes for them to actually begin acting under those documents. Now again, no legal requirement, so it's really at this point more a matter of discretion. So our office, again, typically recommends do not turn those documents over, and there's two main reasons why we typically take this stance. Now they're separate reasons, but they do kind of play off each other a little bit. And the first one is that these documents are amendable and changeable during your lifetime. They're not set in stone the second you sign your name on the dotted line. You can always change the provisions, change the distribution, change who's in charge, or even revoke those documents entirely during your lifetime. Secondly, is the potential for causing some family feuds if everyone is peeking at those documents during your life. Now, there are the common reasons why this can occur, whether it be greed or pettiness, but oftentimes we found it just oftentimes can lead to a lot of hurt feelings. Now, that can be for a range of reasons as to why. For instance, if you have an unequal distribution, so rather than equal to all the children, maybe you have one child getting 60% and another getting 40%. Other instances are who you actually pick to be in charge of your estate following your passing. It's not uncommon to where we've seen a situation where the eldest child wants to be the one in charge and they kind of expect to be in that position just by virtue of being the oldest. But really the best person to be in that position from a practical standpoint is the one who just is familiar with your estate, the one who's involved in helping you out. It's very natural for that person to then step into that role to manage your estate after you pass away. Additionally, if you have distributions that maybe people might not expect, such as gifts to friends or extended family, or even gifts to third parties, whether they be charities or just other organizations you want to support. Finally, another thing that can cause some strife is if you have conditions on the distribution. Now, the most common condition that people place on the distribution is age. And that one is pretty straightforward and most people understand that. The most common age people pick nowadays is age 25, meaning you cannot receive your inheritance until you are at least age 25. But it is not uncommon to where people put other restrictions. Unfortunately, one that has cropped up a little bit more often recently is the requirement of providing clean drug tests to a successor trustee. Now, it's one thing to have that handed to you later in life after mom and dad have passed away and you now see that there's some conditions on you receiving your inheritance. It's another thing entirely to see that in writing during mom and dad's lifetime, and now all of a sudden that child experiencing those issues could be coming at you or the rest of the family, thinking everyone is out to get them, when really it's there to protect them. So again, these two things do kind of play off of each other. What if there's a provision in there that does cause some family strife, which you end up deciding to change later? Well, now we've caused a problem if everybody knows about it and it's caused some family strife, but you decide to change it later. Well, you could have avoided that problem in the first place by not providing those documents to everyone for them to openly inspect and just cause a lot of problems. So really, it all comes down to these documents can always be changed during your lifetime, And there are conditions in there that you can set that could cause some problems, and there's no need to cause those problems prematurely, especially if you can always change them later on if you change your mind. All that brings us to legally required disclosures of those documents. So it's a little bit different depending on whether we're talking about a will versus a trust. So first I'll talk about a will. Under the California Probate Code, section 8200, your executor, that is the person you nominate to manage your estate, they are required to deliver that will to the local probate court within 30 days of your passing. And if there is a probate proceeding that will go on from there, well, that will becomes a part of those court filings. It means it becomes part of that public court record. Additionally, at that point, any interested parties, whether they be beneficiaries or even disinherited parties, are entitled to see a copy of that will. So with that, a will does require disclosure, but it is after your passing, and it does have to be provided to the local probate court by the person you nominate to manage your estate. Next, that brings us to the trust and the required disclosures following your passing for a living trust. Now, a trust, similar to a will, we are governed by the California Probate Code, here specifically section 16061.7. But the trust is different in that the trigger for disclosure is a little bit different. There's more conditions on it, and we don't have to worry about the probate code, but we are handling things privately. So a trustee, that is the person you nominate to take over the management of your estate, they are required to deliver what's called a trust notice to everyone who has an interest in that trust. And they have to do so within 60 days of that trust becoming irrevocable. Now, there's a little bit more that we can go into right there, but for what we're talking about today, your main concern is just that when you set up a trust and you pass away, that trust becomes irrevocable at that point. So at your passing, your trustee has to step in and provide a trust notice to all the interested parties. And that includes beneficiaries, that includes your natural heirs, such as your children, and that also includes those who have been disinherited under that trust. And with that trust notice letter, that trustee is not required to include a complete copy of the trust, but our office always strongly recommends the trustee include a copy with that notice letter, regardless of the circumstances. And there's 3 reasons for that. Firstly, just the convenience factor. Including a copy of the trust with the trust notice letter ensures that everybody has a copy of the documents, they have it all up front, and we don't have to worry about scrambling behind the scenes to make additional copies and provide those to different parties later on when they request them. Secondly, if you're an interested party of a trust, you're entitled to a complete copy of that trust. So even if you didn't want to provide those people copies of the documents, at that point they would be entitled to it, being an interested party. Finally, and this is actually the most important one, is that trust notice letter is sometimes called the 120-day notice letter. Now, we get that 120-day notice letter term from the fact that that notice letter actually has a clause in there that is dictated by the probate code that says the person receiving that notice has 120 days from the date of receipt to challenge the trust's validity. So what that means is if I receive that trust notice letter, I have 120 days from the date of receipt to bring a lawsuit against the trust and challenge that trust validity for whatever reason, whether the trust was set up incorrectly, whether there was undue influence, what have you. And if I do not bring a suit within those 120 days, then I'm precluded by law from later challenging the trust. So it limits that time period that someone can bring that suit. Now, the reason we include a copy of the trust documentation is because the person receiving that notice can actually add an additional 60 days onto that 120 by requesting a copy of the trust. So to just cut off that avenue, we always tell our clients to include a copy of the trust documentation with that notice letter so we can cut off the extra tolling and leave things within that 120 days. With all that, to just kind of summarize, During your lifetime, there is no legal requirement for you to turn over a copy of your will or trust, and in fact, we recommend against doing so. Now, there are notice requirements after your passing, but that's something for your executor or successor trustee to take care of. So the only people that we recommend you actually inform of where those documents are located would be that executor or successor trustee. Otherwise, we'd say, for the most part, you can only let your beneficiaries or children just know that those documents are in place so that they can be aware that that's something that they should expect after you pass away. Thank you for watching. Be sure to like, comment, and subscribe, and ring the little bell to stay up to date. Otherwise, we'll see you again soon.